Hello friends and welcome to the lecture. So students, as we noted, we are covering the municipalities and basically these are the topics that we have scheduled for the discussion under this particular series. Like starting with the introduction part, thereafter the evolution of urban bodies, thereafter the 74th Amendment Act of 1992, thereafter the types of the urban government, thereafter the municipal personnel, thereafter the municipal revenue, thereafter the central council of the local government. So that's the topics that we have scheduled for the discussion. Out of this, basically we have done with the introduction part. We have seen the evolution of urban bodies, and for last few lectures basically we have been discussing upon the 74th Amendment Act of 1992, and the topics that we are completely left with is the types of urban governments, municipal personnel, municipal revenue, and the central council of the local government. So that is the picture that we have created so far altogether. I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit. Okay, so basically in the previous lecture we have decided till here. Okay, and we had come to know that the governor of the state is basically having a right to declare any area as a transitional area, as in a smaller urban area, and as a larger urban area. Okay, on for this basically he considers these points like the population of the area, like the density of the population therein, like the revenue generated for the local administration, like the percentage of employment in the non-agriculture activities, like the economic importance, like such other factors as he may deem fit. Okay, that is what we had discussed in the previous lecture. Now, let's have a talk about the composition part. Okay, all the members of the municipalities shall be elected directly by the people of the municipal area. So here we had come to know about that basically there is a provision of direct elections. What does it mean? It means that the general public could directly participate into the elections and can vote for their candidate. For this purpose, each municipal area shall be divided into the territorial constituencies known as the wards. The state legislature may provide the manner of election of the chairperson of the municipality. It may also provide for the representation of the following persons in the municipalities, which we will see in a little time. But suppose if we talk about the wards, then they are like a division within the municipality. Like if we talk about this area, so this entire area is the municipality. Okay, in this entire area, what happened? Let's suppose the area is divided into certain parts like this. So if we will count these parts 1, 2, 3, 4, 5, 6, and 7. Okay, so here we have 7 division or 7 constituencies, which we broadly called as in wards. Okay, so this is the concept of wards, and this is basically done for the purpose of ease of conducting elections. Ease of conducting election. All right, that's the area, and the people who got elected from these wards formulated the composition of the municipalities. Thereafter, as long as the chairperson of the municipality is concerned. So basically the chairperson is decided by the state legislature. In proper sense, you can say that basically the manner of election in which the chairperson of the municipality would be elected, that is decided by the state legislature. Thereafter, the representation of the following persons could also be provided in the municipality. So what are these persons? Let's see. First is the person having the special knowledge or experience in the municipal administration without the right to vote in the meetings of municipality. Okay, it means that the person who is having the special knowledge or experience, then he could have the representation in the municipality, but the essential thing, which is the right to vote, is not provided to them. Okay, thereafter, the members of the Lok Sabha and the state legislative assembly representing the constituencies that comprise wholly or partly the municipal area. Okay, so if there is any MP, the member of parliament, or any MLA, member of legislative assembly, okay, who is representing the constituencies that comprises the wholly or partly the municipal area, then thereafter the members of the Raj Sabha and the state legislative council, again the MP and the MLC, who are registered as electors within the municipal area, they would have the representation. Thereafter, the chairpersons of the committees, but other than the ward committees, because the ward committee's chairperson must be elected. Okay, but the chairpersons of other committees, they could be represented. Okay, thereafter, the ward committees. So there shall be constituted a ward committee which is consisting one or more wards within the territorial area of the municipality having the population of 3 lakh or more. Okay, so basically the ward committees is not only for the individual wards. Okay, as you can see here. Why? Because it is consisting of one or more wards. Okay, but the thing is within the territorial area of the municipality, which population is 3 lakh or more. If the population is below 3 lakhs, then the provision will not applicable for them. But if the population is 3 lakh or more, then the provision is applicable for them. Thereafter, the state legislature may make provision with respect to the composition and the territorial areas of a ward committee and the manner in which the seats in a ward committee shall be filled. So that is totally depend upon the state legislature. Okay. After ward committees, the next thing what we have is the other committees. In addition to the ward committees, the state legislature also allowed to make any provision for the constitution of other committees. The chairperson of such committees may be made members of the municipality. The chairperson of such committees may be made members of the municipality. Okay. Thereafter, next is the reservation of seats. Like as we had discussed when we talk about the panchayat system. Okay. When we discuss about the panchayat system, then we know there is a reservation for two things, for women and for the ST and SCs. For women, the seats are 1 by 3rd and they fixed. And basically, they including all women, whether they belong to the SC and ST or not. But when we talk about the reservation of ST and SC, it's totally depend upon the portion of their population in the panchayat area. Portion of their population in the panchayat area. Okay, so that's the thing. But here is also the question, like the provision of reservation for ST and SC is not applicable to which state? I had told you in the previous lecture also, so I'm now asking you the question, applicable, or you can say not applicable to which state. For this, you having 30 seconds to think an answer, and your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, and 30. The time's up. So basically, the state is Arunachal Pradesh. So Arunachal Pradesh is the state in which the provision for reservation for ST and SCs is not applicable. Why? Because it is fully inhabited by the indigenous tribe. Fully inhabited by the indigenous tribes. Okay, that's the thing. Now let's talk about the reservation in the terms of the municipalities. The Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to total population in the municipal area. Further, provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SC and STs. So basically, if we go by this statement, so we could say that there is a similarity between reservation provisions in both. Both means the panchayat and municipalities. Alright. Thereafter, the state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SC, STs and women. Like you can say, the seat reservation is basically provided by the Act, but The reservation in terms of the offices of the chairperson in the municipalities for the SCs, STs, and women. That is basically decided by the state legislature. Also make any provision for the reservation of seats in any municipality or office of the chairpersons in municipalities in favor of the backward classes or those classes which are not considered in the SCs and STs. Okay. The reservation of seats as well as the reservation of offices of the chairperson in the municipality for the scheduled caste and the scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is till 2020. So that is also similar with the panchayat, because in panchayat the same kind thing is applicable. Now the duration of the municipalities. So basically the act provides for a 5-year term of office for every municipality. Okay, so what is the time period to continue after selection? 5 years. Okay, however it could be dissolved before the completion of its terms. Further, the flash election to constitute a municipality shall be completed first before the expiry of its duration of 5 years, or in case of dissolution before the expiry of period of 6 months from the date of dissolution. It means that is also like a panchayat. Like if the first thing is that, suppose if the elections were happened in January 2001, so or you can say if the first meeting of municipalities was happened on 1st January 2001, then before 31st December 2006 the elections must be organized. But if somehow, suppose in July 2005, due to some reason, the municipality was dissolved. Okay, in such a case, the fresh new elections must be organized between July 2005 to December 2005. Why? Because that is a time period of 6 months. Okay, so there are two provisions applicable regarding the share. The first is the expiration, second is the dissolution. But where the remainder period, or you can say remainder of the period for which the dissolved municipality would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality of such period. Like you could say, suppose if the municipality was supposed to continue from 1st January 2001 to 31st December 2006 for the term of 5 years. But due to some reason, if in August 2006 the municipality got dissolved, so now look at this period. What you are getting? Like this period is less than 6 months before the expiration. The period is less than 6 months before the expiration. So if this is a condition, then new elections are not necessary. Okay. Why? Because the remainder period is less than 6 months. Okay. Thereafter, moreover, a municipality constituted upon the dissolution of municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after the premature dissolution does not enjoy the full period of 5 years but remains in the office only for the remainder of the period. Like we had discussed in the previous lectures also. Suppose if the first meeting happened on 1st January 2001, it shall continue till 31st December 2006. That's the thing. But on 1st January 2006, the previous municipality got dissolved and the newly formed municipality meet. So if the municipality was selected on 1st January 2001, it does not mean that the municipality will continue till 31st December 2011 for the period of 5 years. Because the provision said the newly formed municipality will only continue till the time period the previous one would have completed. Okay, it means that from 1st January to 31st January 2006, there is the time period is 1 year. So the newly formed municipality will only continue for the time period of 1 year. Okay, which is also called as an remainder time period. Okay, that's the thing. The Act also makes two more provisions with respect to the dissolution. Like, a municipality must be given a reasonable opportunity of being heard before its dissolution. It means that if the state legislature agrees to dissolve the municipality, so before this, there must be a opportunity for hearing by the municipality. Okay, if the hearing opportunity is not provided for the municipality, then it could not be dissolved that easily. Thereafter, no amendment of any law for the time being in force shall cause dissolution of municipality before the expiry of the 5 years term. It means that suppose any amendment of any law passed by the state legislature which is inclined towards the dissolution of the municipality. All right, but this was passed during the time period of 1st January 2001 to 31st January 2006. The 5 years time period of the municipality. So in between, municipality could not be dissolved. Alright, it means that without completing the 5 years, the municipality could not be dissolved. Thereafter, now let's talk about the disqualifications, like on which basis the person could be disqualified to be the part of the municipality. First, a person shall be disqualified for being chosen or as for being a member of municipality if he is so disqualified on the following basis. First is under any law for the time being in force for the purpose of the elections to the legislature of state concerned. Okay. Thereafter, under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all question of disqualification shall be referred to such authority as the state legislature determines. So this provisions also having the similarity with the panchayat system. Okay. Thereafter, what is the State Election Commission? The superintendence, direction, and control of the preparation of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. Alright. Thereafter, the state legislature may make provision with respect to all matters relating to elections to the municipalities. That's depend upon the state legislature. Alright. Thereafter, what are the powers and functions? So basically, the state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of the self-government in the urban area. Such a scheme may contain provisions for the devolution of powers and responsibilities upon the municipalities at the appropriate level with respect to the followings. First, the preparation of plans for the economic development and the social justice, which we also called as a socio-economic plans. Alright. Thereafter, the implementation of schemes for economic development and the social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th schedule. And we know that 12th schedule was basically introduced by the 74th Amendment Act of 1992 along with Part 9th A. Alright, that's the thing. So students, basically this lecture we have completed till here. In the next lecture we will continue from here. Till then, just revise the facts and figures whatsoever we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.